Hi, I'm Andrew Walker, the Minnesota Bankruptcy Attorney. This video will explain what questions to expect at a typical bankruptcy hearing and how to answer them. In addition to this video, we will talk with you one-on-one before the hearing. Now, some of these questions are individualized, so we will make sure that you know what to say beforehand. This video is just to give you a general idea of what the hearing will be like. The hearing is called the meeting of creditors, but don't worry, because creditors almost never come. If any creditors do come, then the only thing they can do is ask you about your income and assets, the money you make, and the things you own. Now, one of our attorneys will be with you for the questions, but technically, we're not allowed to answer for you because attorneys cannot be witnesses in their own cases. What we can do, however, is rephrase any confusing questions in a way that makes the answer obvious. Now, the best way to answer the questions is with a yes or with a no. The trustee has about 30 or 40 of these hearings to get through today, and they will see right away from our paperwork that you haven't done anything wrong and you are entitled to the discharge. This hearing is just a formality to make sure that everything is on the up and up, and it is, because we got all those bank statements, pay stubs, and other financial documents from you earlier as proof. Now, I know it's really annoying to gather them up, but spending the time to get things right will make the hearing go smoothly. If you are a married couple, then you should both answer each question out loud. This is recorded, and it is not good proof if only one person speaks. The hearing usually takes about 5 to 10 minutes per case, and you will likely hear the person before you. They ask the same questions of everybody, so this is a great opportunity to get familiar with the questions. Okay, so the questions go like this. First, state your name for the record. Then, did you read the bankruptcy information sheet? Yes, we gave that to you before the hearing. Then they'll ask, did you read the papers that were filed with the court? Yes, that's the long document we signed in my office or over the phone about a month ago. Are there any errors or omissions on the paperwork that you would like to point out? Now, we have an unlimited right to amend or change the paperwork, so if anything needs to be corrected, just tell us. Then they'll ask, have you ever filed bankruptcy in the past? Then they'll ask if they have a true and correct copy of your most recent tax return. Yes, we sent it to them earlier. After that, they'll ask, do you have a domestic support obligation? This means, do you pay child support or alimony to anyone? After that, they'll ask if you have any claims for damages against anyone. This means things like lawsuits for a car accident or a slip and fall or maybe an insurance claim. Then they'll ask, do you have a house or any land or real property? If so, then they will ask how we decided what the value is, such as by a realtor's market analysis or by Zillow.com. Then they'll ask, have you refinanced the house or paid extra on the mortgage in the last few years? Then they will ask if you own a business. If so, they'll ask you some questions about the business, and we'll prepare you for that one-on-one. Then they will ask if in the 90 days before we filed your case, did any creditor take anything from you by wage garnishment or bank levy? In those same 90 days, did you voluntarily pay back any unsecured creditors, like a credit card, $600 or more? Then they'll ask, in the year before filing the case, did you pay back $625 or more to a friend or family member? After that, they'll ask, in the 2 years before filing the case, did you sell, transfer, or give away anything worth $1,000 or more? If so, then they'll ask what the item was, how much did you get paid for it, and whether that was a fair price for the item. Then, in the 6 years before filing the case, did you sell, transfer, or give away anything worth $1,000 or more to a friend or family member? If so, they'll ask what the item was, how much you got paid for it, and if that was a fair price for the item. And the last one, and it's not really a question, is they'll let you know that if somebody dies in the 6 months after filing, and because of that you're set to receive an inheritance or any life insurance, then some of that money can go into the bankruptcy. Now, please call my office first if someone goes into hospice. There are things that can be done before the person passes away, but not afterwards. And then they'll say, no further questions. Relax. These hearings are routine. Most people file bankruptcy for good reason, and they're not trying to make it difficult or nasty. The purpose of the hearing is to find people who are doing bad things, like burying gold bricks in the backyard, or who have sold a Ferrari to their brother for $1. I know that if you had gold bricks or a Ferrari, then you would not have called to file bankruptcy, so I don't lose too much sleep over things like that. In the coming days, we will send more information about what to do after the hearing, but essentially, it's all over but the waiting. The creditors still have 2 months to object to the discharge if they have evidence that their debts should survive bankruptcy, but this is very rare. Walker & Walker still represents you for anything involving the bankruptcy, so don't hesitate to reach out with questions. My next message will explain how to start rebuilding your credit, because that's what comes next in life. Thanks for your time.